I think maybe even Dirty Jersey Rat. Dirty Jersey. Yay! I love that song.
We have some updates and the biggest love story the state of Minnesota has ever known. No, and it's not Helen of Troy in Paris. It's not Romeo. And not of Juliet and of her Romeo. No, chat. No. It is of Aaron Imholte and his betrothed, Nicholas Rekieta. Yes, chat. It is time. Anna, I hope you're out there watching. We finally got some content for you. So buckle up. And yes, to quote, as quoted, it was a very loving and romantic relationship. Now, chat, this is, and not only for chat, but the dabblers out there, because I know some of you are probably going to clip this. Some of you are going to watch this. Like, we need to get some ground rules out of the way. Look, I understand, Aaron, you guys don't like Aaron. I understand it's even more than that. You guys, Aaron's not a good person. Aaron Imholte's not a good person, and I get that. And I get that you guys think Aaron Imholte is like the baddest bad that has ever batted. Like, he's a bad man. He's just bad. I get it. Aaron Imholte's bad. He's like worse than everybody in the SS. You guys have to put up on big slides, like on big, put on big screen projectors in rooms. Aaron is not a good person. We get it. He's the worst of the worst human beings imaginable. Fucking ISIS, those guys are fucking pussies compared to Aaron. The guys, drug dealers, the cartel members chopping people's heads off with chainsaws. They're not as bad as Aaron. I get it. Aaron's a monster. The baddest man ever imaginable. I get it. But let's get to what happened, because none of that matters. None of that matters here. So what do we have? Well, if you guys remember, we had the long-awaited final part of the HRO, the harassment restraining order hearing that Aaron had filed against Nick. And what happened? Well, at these hearings we saw, going back to the first part of the hearing that occurred last summer. If you guys remember, that is the one where we actually got to watch it on Zoom. And Nick comes in dressed up like the biggest fucking goober in the world with his little Bono glasses on, and is just like, looking like a complete douchebag. And remember, Aaron's alleging these people are harassing him and doing all kinds of things. And this is where I warned the dabblers that, yeah, Aaron's case is kind of rickety and shaky. I didn't think he was going to win. But he's got a lot of good arguments that he can make that, depending on how Nick Rekieta reacted to them, would help out a lot. Because, having your little puppet show in the desert where you share private images of him, you drag a you guys drag a refrigerator 1,000 miles. You bring out his former high school friends and all this. It to an average person looks fucking weird. It looks ridiculous. And I know you guys pish posh that. And then we, had a bunch of continuances. And we got to the final things of this hearing here in June. And what happened then? Well, in the meantime of that, we had another Hackamania where, once again, Nick and Melton put up pictures of Aaron, pictures that nobody had anywhere else. They had leaked his search history off Google. And then you also fly out Aaron's fucking goober, douchebag, local radio guy friend from high school again. And you do all this crap. It seems kind of weird, but okay. Once again, I get it. We all don't appreciate comedy. And then we finally had the rest of the hearing. And what did Nick do in that hearing? Nick acted like a complete fucking retard. And this is where I'll point out. Here's how Nick would have won this. If Nick would have shut the fuck up, and then when it came time for the hearing, if he came in and testified, a jacket that is solid colors, a shirt that is solid colors, and a tie that's solid colors. And if he had just come in and said, Your Honor, this man took pictures of my wife that were nude and shared them around, and he ended up pleading guilty to it. And he harassed my wife. And we merely had our laughs about him. We all came out to his court hearing to shame him and embarrass him. And that's not illegal. That is just public shaming. That's all you had to do. And he probably would have won. And this would have been over a long time ago. You would have won it. You had every ability to win this. But no, that didn't happen. And instead, well, I'm sorry, dabblers, but we're going to have some really tough discussions about this guy you've been sucking off to use to make fun of Aaron. Because it's a little awkward. It's a little awkward. So here we go. Here we go. It's going to be a little awkward, chat. So this is from the judge. And I apologize for this not being the best quality, but when it's taken off of a PDF and it's put into a JPEG and then I have to put it back into a PDF format, I don't know why we don't have the real document available, but whatever. Anyway, this is, remember, Aaron's attorney was 11 days late, and then Nick was seeking a motion to dismiss. Well, the court's going to rehash a lot of stuff here, and here we go, because this is going to be good. Get yourself ready, chat. Here we go. Here we go. So this had two separate dates, August 29th of 2025 and June 5th of 2026, for contested evidentiary hearings on a harassment restraining order. And they says Aaron's been represented by Brian Johnson, who's done a great job. And Nick has been represented by two attorneys, Brian Lewis and Frank White. And we're going to get to some things here. So in June of 2025, Aaron filed the motions for this. He got an ex parte. And then Nick timely requested a hearing on the same date. And now here's the point. Much of the procedural history is outlined in the previous things here. The parties are two adults who have financial interest in using their voices across platforms to communicate about certain topics. Nick has repeatedly raised First Amendment in opposition to the HRO. At the first appearance held by Zoom, many individuals interested in this, due to the public platforms, appeared and disrupted the proceedings. And I will say, whether you're on the farms or you're a dabbler, yes, you guys fucked that all up for everybody. So thank you. I'm not really thanking you. So whoever did it, you're an asshole. And it said, still the court held approximately 3 hours of testimony and received a number of exhibits. This right here alone, 3 hours for a restraining order, is absolutely ridiculous. I mean, I've had them that go an hour, 2 hours, 3 hours. I've had a couple. That's a long time to have a protection order hearing. That alone right there is already kind of pushing credulity. And it says respondent through lead counsel at the time had prepared numerous lengthy exhibits for potential submission. And guys, respondent is Nick. Certain potential exhibits were inadmissible unless the court received the whole video. For example, respondent argued it was not enough for the court to review respondent, another respondent of a separate but related petition for an HRO, another male, and a male in an apparent luchador-style wrestling mask with an apparent handheld Muppet making jokes together about a photo of the petitioner displayed in an event called Hackamania, yearly held in Las Vegas. He's not saying this because you guys are cool. He's saying he's making fun of you guys, just so you understand out there. Respondent's counsel contended the court needed to review the entirety of the exhibits as the information was necessary to understand Nick's position. So Nick literally did no, Your Honor, you need to watch all of Hackamania. No. You need the context. You don't understand the comedy of this. Your Honor, you have to watch all the Hackamania. You have to watch the, you have to watch the verisimilitude of Tukey with his hand up a puppet's ass talking about Aaron and how it all works. And then you have to listen to Moody going, "Nar." And you have to listen to Carl going like, "Oh." You have to understand it all, Your Honor. Yes, because making the judge walk Hackamania, he's going to be like, I agree, this Aaron guy's a faggot. No. And also, Patrick Melton, you really need to look at bailing out of this because it's not going to be good for you. The respondent also we don't know what the rest of that is, so we'll keep moving. The parties agreed that an in-person hearing was necessary to handle the evidentiary issues given the interruptions, the undecided issues, and the volume of exhibits, and the unexpected length of testimony. Yep. Also, there were some technology issues there, too. So the court granted a request for a status conference and issued a scheduling order. It set the hearing for October 25th. The scheduling order also agreed terms by the parties, a timeline for a transcript, discovery requirements, witness list, objections, a sequestration order, and requirements that individuals gauge acceptable behavior during court, including from refraining of audio recording of the matter. Yes, chat. This is a big thing here. We're going to come back to this theme. Acceptable behavior during court. This is a secret tool that's going to help us later. It's going to be a secret tool that's going to help us later. Don't worry. We're going to get back to that. Aaron requested a continuance due to a conflict, his attorney having a sentencing date issue, and Aaron's stuff too. The court denied the continuance. The parties appeared in person. After a chambers discussion, the parties indicated there may be a resolution. So notice, Aaron and Nick's side indicated to the court there's something to work out, because notice the court saying, well, I thought there was. Unless we're going to argue the judge is lying. And then I guess we're, once again, this is a conspiracy, I guess, now. The court provided both parties separate rooms and the use of the court for the full day, breaking for lunch and return. The parties indicated they were actively working on a resolution and they would submit an order to the court if another hearing was needed. The following week, the court received correspondence indicating that events had derailed the resolution. Of note, Aaron was upset that Nick had allegedly spent part of his time drawing a picture captioned "Dork Bert Goes to Court," and later publicly shared the picture by Melton, another HRO recipient who was represented by Nick's attorneys, and as a colleague of Nick and fellow Hackamania presenter. This is where the judge points out that he's noticing things. And we're not talking about the Jew noticing. He's just noticing. And was believed to be a potential witness in this case. Aaron indicated that this changed the potential settlement. Yeah. And remember, Chad, if you haven't seen this, Nick wrote and drew he drew a thing of Aaron. He drew a thing of Aaron. Like, let's not lie. Why would you share it? And why would Hackamania, why would this little piggy and all you dabbler guys sit there and laugh and jack off about it if it was Nick saying, look, my attorney's a fucking goober? Oh, you wouldn't. Just fucking say it with your chest. You were making fun of Aaron. Say it with your chest. What are you scared of? Well, because you realize that would look like harassing behavior. And that would be bad. But, what do I know? I'm just the creme brulee lawyer. I don't know what I'm talking about. I don't know what I'm talking about. But don't worry, Chad. It gets better from here. This is... why did this... I hate this when it goes in the wrong fucking order. Thank you. Thank you, Adobe. You suck. Anyways, the court had a telephone motion on November 14th with counsel from both parties. The court was advised by Nick's attorney that the drawing was of him, not of Aaron. Now notice, Nick's attorneys cucked themselves and jumped on the grenade for Nick. No, Your Honor, my client was making fun of me and calling me a fucking retard. What? Like, have some fucking respect for yourself. Have some respect for yourself. You're going to let your client do that to you? And then the other guy you're representing is looking at you and laughing at you. No, it's such bullshit. That's such bullshit. And I guarantee you the judge saw through that. Number one. Number two, Brian Lewis or Frank White. Is it worth lying for Nick for your fucking law license? Is it worth that? Defending Nick's honor and the fucking, we're protecting the Dabbleverse, and you know how the Dabbleverse is protecting the institution of shock jock comedy and shock jock radio. You know, they're here guarding America. You know, we need them on that wall. Is it worth it risking your fucking law license for all of this? This is so fucking stupid. It's so fucking retarded. Why would you risk that? Why would you risk that? Number one, but then more importantly, just, you know, I wouldn't let my fucking client do that to me. Fuck that. Are there times where I've jumped on a grenade for a client, like maybe they misunderstood how they would get there? And like, Your Honor, maybe I told them the wrong time. I don't know. Maybe they misunderstood me, Your Honor. I'll jump on that grenade. I've done that before. Any good attorney will. But not like, Your Honor, my client's a piece of shit like that. Fuck that. That's pathetic. That's pathetic. Have some fucking self-respect. So, the parties continue to engage in discussions. Notice there's nothing here that says, I don't want to do this anymore. On February 23rd, they held another scheduling conference to check in. The court was advised by Mr. Lewis that Frank White had been unavailable due to personal injury issues. Again, the details are personal, thus not included in this order. We're going to get back to this part too, because this kind of matters for what happened to Aaron's attorney. The court did not receive any written filings from Nick's attorney confirming the delay in any discussions or setting of a continued evidentiary hearing. For months, any delay in this matter being reset was partially, if not largely, attributable to Nick and or his counsel. Now, I understand Nick's like, I did not tell them to do nothing. But once again, Nick's getting back to this issue of apparently his attorneys don't talk to him or they don't do what he wants, which is malpractice, is something you should grieve them for. And Patrick Melton, you should understand, if these guys fucking suck as much as Nick keeps saying they do, why are you using them? Find your own attorney who's gonna like actually communicate. And if he wants to file things or needs to file things, he fucking does it. Don't rely on these fucking goobers, because Nick is establishing their goobers. Number one, they'll let Nick shit all over them. And then number two, Nick's like, oh, this didn't happen. Well, then, Nick, who's telling the fucking truth here? I believe the judge over you, buddy. I do. Sorry. The court set a settlement conference for April 13th, the day after the hollowed, you know, the gathering to protect America in the high desert. Hackamania. Mr. Lewis informed the court that the parties and Mr. Melton, whose case was tracking and needed to be reset, had been unable to reach a settlement. Finally, they sought to cancel the April hearing so they could attend the Hackamania with Melton, who also sought a continuance. Aaron objected, noting the Hackamania was a source of the alleged harassing conduct. It's a partial basis for the petition, yeah. Also, it doesn't help, once again, you don't object the week before the hearing. You should have objected and said, we can't do this back in, February. Like, right here is the time. This is the time to do it. February 23rd, you're like, Your Honor, we're going to be out of town these days. We need a different date. You don't come up to the week before the hearing and say, well, Judge, we need more time. That's not how that works. That's not how that works. Not how that works. Not how that works. So the court preliminarily denied the continuance, noting the information being presented for several months by Nick's counsel. The court allowed for a stipulated agreement to avoid violations of the HRO or potential future acts that could be added to an amended HRO petition. So, guys, and this is once again dabblers. I know Nick tried to tell you, like, if they just ran out the clock, it would go away, or you can't add things to it. No, even the judge is agreeing you can amend your petitions, and if you engage in further harassing behavior, that can affect what you're dealing with. Like, it's not like that's all untouchable behavior. So even the court's recognizing, like, what are we doing here? What are we doing? The respondents didn't sign a stipulation. The hearing remained scheduled. Nick appeared on the 13th. Melton did not, after a last-minute doctor's note. He didn't appear for the hearing and thus would not have been available as a witness. The court set the matters for June 5th. As the parties were leaving, Nick loudly elected to attempt to educate Mr. Johnson, Aaron's attorney, on the harassment statute. I know Nick tried to sit here and tell you, like, guys, you don't understand. I did it. And it was like, I was using psychological warfare. I big dogged him. I stood up to him and said, you better know the statutes, bucko, because I do. I'm sure in Nick's head, this Walter Mitty idea of what happened, I'm sure it was basically that. He sounded like a fucking lunatic. And I'm sure that didn't impress the judge, because now you're looking like the crazy man. Because Aaron comes in and says, Your Honor, this crazy guy's acting like a fucking stalker. And what do you have? A crazy guy acting like a fucking crazy person. Because who yells at the attorneys? Fucking crazy people. Just think about that. Yes, and then everyone clapped. And the judge said, the judge took off his cloak and he said, hey, kid, catch. And he threw it to Nick, just like Mean Joe Green. That's exactly how Nick probably thought it goes. I'm sure that's how Nick thought this went. But, for the dabblers out there, this is fucking cringe. This is cringe. Holy shit. On June 5th, the parties appeared for the continued hearing. The hearing lasted all day, involving testimony from Aaron and Nick, submission of exhibits, and the denial of a motion to dismiss. At several points in Nick's testimony, he became argumentative, especially with Aaron's attorney, Brian. The court eventually had to call a recess to ensure Nick was able to conduct himself in a manner that avoided need to find him in contempt. Nick threw a fucking temper tantrum out there. Dabble sisters. This is the guy you're playing footsie with to own Aaron. A grown-ass man who had a fucking temper tantrum in court. Because when you want to show you're not a crazy lunatic stalker, coming into court and saying, Your Honor, but I've seen his penis and it's crooked and he ate my goo. That's the real pro gamer move. That surely doesn't sound like a fucking psychopath stalker. Your Honor, no, I had to show naked pictures of him because we had a special private agreement in our private relationship we had. And he's my boyfriend, Your Honor. Do you think that's how you need to come across? Is that how you win this? Or do you, like I said before, you come in? Your Honor, this man harassed my wife. And Your Honor, all the stuff he's complaining about, it's over a year ago. We haven't done anything else since then. This man's just a criminal and he's washed up. And he's just mad at the world. Nobody watches his show. And he fakes super tips and he fakes his chats. I pity Aaron. I feel sad for him because he's such a loser. Thank you, Your Honor. And get down at the stand. You know which one probably would have made you look like a good guy and win? That. Not what you did. And also screaming faggot at people. I want to say the word faggot in court. Do you think that won today for you? It doesn't sound like it did, buddy. It doesn't sound like it did. Oh, they tolerate Nick to fuck with Aaron. They do a lot more than tolerate him. They bob on his knob like it's corn on the cob. I mean, really. Just saying. It's just ridiculous. I feel like Menelaus in fucking Troy. It's like, this is what you're using to fight Aaron? This is your champion? Oh. Anyways, Nick was able to complete his testimony, was allowed significant latitude to explain his knowledge of a viewpoint on the facts in the case and the relationship with the First Amendment. Nick indicated several times during his case that he believes he understands the law very clearly and certainly better than Aaron and his attorney. just Nick, the judge does not think you're funny. He does not think you're cool. And he doesn't think you know what you're talking about. Read the social cues, buddy. He thinks you're a fucking goober. They say Mr. Lewis, to his credit, had no issues with appropriately advocating for his client legal and factual position, meaning Brian did good job. Like, when you're up there on stage, you're like, I'll put on my lawyer hat. Ha! No, it's gay. It's cringe. Like you weren't fucking impressing anybody. Both parties agreed to a briefing schedule. Aaron's initial brief was due June 26th. Nick's was due July 31st. And then Aaron had till August 21st to respond. It was anticipated that Aaron's initial brief would address the merits of the alleged acts that could establish a statutory basis for the First Amendment or the HRO. Nick would challenge that basis, raise additional First Amendment challenges, and that Aaron would then respond to additional legal arguments. Aaron filed a request to extend to July 3rd due to an illness and noted he was requesting a transcript. The court granted the request and ordered the transcript be provided. Nick could request a similar extension with a potential deadline reply. Aaron didn't file until July 14th, 11 days late. Aaron filed an apology for the delay, noting for the record he had been dealing with certain personal issues, and agreed that Nick's briefing deadline should be extended, and it should. Because of that delay. Because of that delay. Prior to Aaron's brief being submitted, Nick's counsel filed a letter asking the case be dismissed. After Aaron's counsel responded via email, the substance of the rationale given in the email was provided in Aaron's letter requesting acceptance of the late briefing. Nick's counsel received this information, as well as with Mr. White's situation. No additional information need to be filed publicly. This right here, chat, is equal application of the rules. Whatever Frank White went through, we're not going to hash it up. Shit happens in life. Aaron's attorney needed that grace. The court extended it to him. Equal treatment. This isn't evil Stearns County conspiracy. I don't think Alicia Sweep was speaking to anybody. I don't think Jim Felt was talking to anybody. Evil Detective Pomplin wasn't talking to anybody. The evil people at the church weren't talking to anybody. The judge just looked and said, hey, I cut you some slack. I'm cutting you some slack. We're going to work on this together. Notice he doesn't even take the time. Whatever 4 factors Nick is citing doesn't, from what I've been able to see people doing research on, doesn't even fucking apply in this situation. The court doesn't even waste time addressing it. At the time the briefing schedule was open-ended, as Aaron had not offered a second revised schedule. Nick indicated in the letters that the brief was likely largely written before the continued hearing. And this is where it gets funny, chat, because Nick's going to get called out on shit. This is where it gets even better. That his client's status as a public figure regularly sought after for legal commentary, who continues to receive national media attention as recently as this morning. I'm pretty sure that was the whole Daily Mail reporting on Nick being a fucking convicted of felony cocaine possession and everything. And believes his First Amendment rights are being injured in the delay. But if he's being sought after for legal commentary and everybody believes in him and likes him and thinks he's cool and hip and popular, how are his rights being injured? Oh. These filings predate Aaron's brief and the letter Aaron's counsel filed. While there has been a delay in Aaron's briefing schedule, the final deadline has not been extended. The matter is not to be sent under advisement until August 21st. As Nick's counsel appears to argue, Aaron did not need to request a transcript and likely would have drafted his brief before the hearing. And once again, this is the judge. Like, I know Nick acts like he doesn't do any of this stuff, but like, if you're not doing this, Nick, then your attorneys are the dumbest fucking in the world. I don't know which one you and they take you. They literally you give them money and they take it from you, and then they fucking suck. So not only has Aaron cucked you, but these attorneys are cucking you. They're cucking you out of money. If that's what you want to say and that's how you want to handle this, I guess. I don't know. You're the one saying it, not me. If this was all true, it's unclear why Nick and his attorneys haven't been able to hammer out their own shit. Basically, if you're making all these fucking claims up, why aren't you fucking done? Plus, the additional briefing time allotted to Nick, allowing him to prepare to argue against 2 or more harassing acts. Yeah, it's just like, you're talking all this shit, but there you sit not doing anything. Oh, we'll file your fucking brief. Let's go. Let's go. You know, claiming it's all bullshit. Well, the court has preliminarily reviewed the brief. What does it do? Well, it focuses on the facts in the case, provides citations to transcripts and exhibits, and cites the statute. So they did the thing. You just can't go in there and go, that's not true. That's all you've done so far. It's not right. You don't know the statute. Prove he doesn't know it. Prove he doesn't know it. Aaron does not seek to address any of the potential First Amendment claims Nick indicates will be raised, and does not cite additional case law. To be fair, he doesn't necessarily know all the things Nick is going to raise, so he should be able to respond later, but the court's going to address that. While the deadline remains open, Nick continues to file documents seeking relief. With 2 weeks left in the original briefing window, but in agreement for an extension August 14th, Nick filed a motion to dismiss. The next day, Nick filed a slightly amended motion to dismiss, clarifying the request was to grant the motion, and attached to the filings is a letter seeking a fee waiver. And this is where it's like, to be fair, they should be granted a fee waiver. It's like, we're having to respond to this shit. And I agree. So they say in total, the respondents finally seeking dismissal are as long as Aaron's principal brief. They say they first seek another hearing date to address the motion. Remember, the guy, he's like, I need this over now. I need another court date also, Judge. It's like, which one do you fucking want? Do you want it to be over, or do you want to have a million hearings? You got to pick. You got to pick. You know, they indicate that the attorneys are unavailable from, through the middle of July, which is why Respondents' Counsel agreed to a July 31st responsive deadline. Nick indicates that his counsel will be gone again until November. Well, I was going to say gone until November, but August 15th. Respondent notes his First Amendment injuries received in the purported delay. Nick fails to account for the months where his attorney was not available. Once again, I know Nick's saying that's not true, but it's true. It's true. Fails to recognize that at the first hearing, his attorney thought to introduce hours-long video under the rule of completeness. Yes. It's been dragging on. You wanted to make him watch full segments of Hackamania. You don't get to come up the works and then bitch about it. Sought to introduce some of these items as impeachment, thus never sharing them with Aaron, which means we got to figure out what's going on, which means there's no meaningful preparation to ensure the hearing could have been conducted in a reasonable amount of time. Yeah. Just keeping that shit all in your pocket and then dumping it on the table. And we're like, okay, we're ready to go. That's not how that works. It's not how any of this works. It's not how any of this works. Oh, just Jesus. Just Jesus. Jesus de Cristo. Just don't make no sense, chat. They could have been conducted, or otherwise fails to note the circumstance of the initial Zoom hearing, fails to reference a full day of court's calendar allotted to Aaron and Nick to discuss a resolution that would adopt the terms, that both parties represented were unique to their professional status, part of which he apparently spent doodling. Yes, Nick, drawing your little fucking gay little Dorkberg picture looks like you're out there fucking off. And then, when you had the Zoom hearing, you're just like, Mom, You look like you don't. Yes, remember, looking like an asshole in court is never a good idea. You're not owning anybody except yourself. That's a free legal tip for everybody. Don't look like a fucking faggot in the courtroom. It's never a good idea. It fails to account for the court denying Aaron's continuance as requested for similar reasons to the denial of Nick's request. And it says both parties should have been aware of the court dates that were agreed to. Yeah, so they agreed to the 13th. Thus, it's unclear why Nick booked a plane ticket or agreed to participate in Hackamania, the very event which is part of the hearing of this case. Yes, so they agreed to this. And then they come back later and ask for a continuance. Why would you do that? Why? 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 Why would you do that? Or even better, why Kayla had to attend the hearing only involving Nick and Aaron. Yes. Why did Kayla have to be there? Well, you don't understand, so they took the wet eye flight back. It was so bad. She could have sat in the fucking car. She could have gone to a coffee shop. She could have driven home. Why did she have to come sit in the fucking courtroom? Remember, this is the woman who's like, I'm so terrified of Elwin. Elwin's so scary. Oh! But she sat in the courtroom with him. Apparently not that bad. Makes you wonder, chat. Makes you wonder. But I'm just asking questions. And it fails to account for the full day allotted for continued hearings, a hearing that was extended by a delay and break so that Nick himself avoided making further statements that could be deemed contentious. Yes. Because you kept acting like a fucking retard. Nick instead submitted a 52-paragraph affidavit and 4-page memorandum while his brief is pending. Yes. While you're supposed to drop some, I know the statute. Then write about the fucking statute. Instead, you cried and cried. While respondent's memorandum addresses the email sent by Brian Johnson and received by Nick's counsel, it does not address the rationale provided by Brian in apologizing for his delay and seeking an extended deadline. As such, Nick asked the court for a motion hearing to address the failure to timely request the extension, in part because Nick's attorney is unavailable during part of his remaining briefing schedule. It is unclear how a motion hearing at some undisclosed time will help with Nick's concerns for being done. Yeah. Yeah, it's a 52-paragraph affidavit. 52 paragraphs. 52 paragraphs. So, yeah. It's unclear why the respondent was or is not actively preparing his arguments, especially when noting Aaron should have had his brief largely completed prior to the contested hearings, asserting free speech grounds that Nick and counsel are well-versed in. That's another fuck you from the judge. That well-versed in. He doesn't think you're well-versed in it. He doesn't. And dealing with issues that are not unique. Once again, he's mocking you. He's mocking you. Moreover, Nick continues to be regularly sought after for legal commentary and continues to receive national media attention. Thus, it's unclear how the delay is actually impinging on his reputation, interest, or constitutional rights. Now, Nick, this is where be a man and just tell him, Your Honor, I want to talk about Aaron. Unless you realize that makes you sound like the fucking lunatic stalker that Aaron is trying to make you out to be. No, but you notice Nick won't do that because he's not that stupid. Well, I'd like to think he's not that dumb. Let's see if he is. To the extent Nick himself complains of the 11-week briefing schedule, the court notes is prepared to address this matter when the parties were. In Nick's deadline was set for July 31st and has not passed. Yeah. You could still file your fucking motion and be done. You could file at any time. To date, Nick has not filed anything substantive relating to the merits of the case. The evidence was all submitted and is before the court. The court finds the briefings agreed upon by the parties will be helpful. Nick himself agrees this is not a complicated response. Calling the petition obviously frivolous. Calling petitioner's brief embarrassing and short, claiming it blatantly misstates the law, facts, and record. And as a perfect representation of Aaron's naked attempt to falsely utilize the court's right to suppress Nick's rights. Moreover, Nick, who is a lawyer and regularly injected his testimony with his own legal knowledge, gave detailed answers to his belief that his actions, if proven, were protected under the First Amendment. Noting that he was pretty good at the First Amendment and clearly articulating his statements in this case were protected speech. He's calling you out, Nick. He's not like actually like, oh, I think Mr. Rekieta is a good jurisprudential scholar. He's not. He's not. Respondent was also combative and argumentative with Brian Johnson, speculating on Brian's personal life. The court is, and this is the pro gamer move, chat. This is the pro gamer move of everything else. The court is concerned that Nick's motivation in attempting to require Brian to prove additional information in the file is similarly designed with the purpose of antagonizing or attempting to harass counsel. You know, I'm just the creme brulee lawyer. I'm the sandwich man. I'm fat. I'm fat, Chad, if you didn't know. Fat. I'm fat. But, you know, I did pass the bar. I did go to law school. And this is something we need to think about here. In Ohio, you know, this idea of antagonizing and embarrassing somebody, we would call that harassment. So when you're at a harassment restraining order hearing and it looks like you're harassing parties, you're kind of like answering the question for the other side. And not only when you're harassing, you know, opposing counsel, but you're up there screaming about another man's cock and about this special secret contract relationship you had and why you had to travel 1,000 miles to go show half-naked pictures of him and laugh at him and do all this weird shit. As Mersh says, your puppet show in the desert. You're kind of establishing you're fucking harassing somebody. You're kind of telling everybody, you know, I'll show you harassment because you're harassing people. You know, Aaron's out here trying to say you're out, you know, and that's funny because I know a lot of dabbers are like, these laws are meant to protect women from crazy stalker boyfriends who act like this. So you're playing yourself here. You're playing yourself. Just saying here. Just saying. Something to think about. It's something to think about. Once again, what do I know? What do I know? I don't know much. But what do I know? What do I know? We'll keep going, though. Regardless, the briefing deadlines have not expired. Nix fails to cite authority that would require the court to dismiss the petition due to a late filed brief, later argued by counsel as for family reasons. Yeah. I know all that shit Nick was citing don't actually apply here, looks like. So Nick does not cite authority that a motion dismissed for failing to file a brief as opposed to failing to appear or failing to present evidence is appropriate after a fully contested hearing and a harassment restraining order. It sounds like Nick kind of misapplied authority here. It's like, you know, you got to know them statutes. Got to know that law. Although he fails to accurately include his own involvement in the delays, it's absolutely correct this HRO has gone on much longer than the court or the parties hoped for. Yes. Once again, self-induced failures. The court has done everything possible to ensure the parties are heard, and for months, respondent's own counsel was not prepared to respond and move forward. Yeah. Oof. Now Nick has the opportunity to fully litigate his defense. Yep. The court is prepared to take the matter under advisement upon submission of the final briefs. Setting a motion hearing when Nick makes no claim the briefing delay was actually Aaron's own fault any more than the delay in setting the final hearing was Nick's own fault simply invites further delay. It does. Nick correctly states the agreed upon briefing schedule was premised on Aaron filing a timely brief. The court understands the reason posited, family issues and illness for an extension, but it's not fair to Mr. Lewis and Nick to require their brief to be due within a window of time where Brian is unavailable. For these reasons, and to ensure fairness, the court will extend Nick's briefing deadline to August 21st. Aaron will not be allowed to submit a reply brief without the leave of court, meaning he can, but he has to file a motion with the court and ask for leave, saying, Your Honor, we would like to respond. Now, the court can grant it or it could deny it, but they have to ask first. The court will then take the matter under the advisement on August 21st. So defendant's motion to dismiss is denied. Aaron's late brief is accepted for the reasons articulated. Nick has till the 21st to respond. Aaron may not submit a reply brief without permission of the court, and the court will take everything under advisement on the 21st. I mean, if it, like, once again, if you had just not acted like a complete fucking retard, you'd have been done already and probably won. As I stated from the beginning, this is yours to lose. And now Aaron's out in front. Now, you have a great advantage, Nick. Aaron loves stepping on rakes. He's like a rake-seeking missile. So he's probably going to step on one here soon. But in the meantime, you just pulled your balls out and stomped all over them with golf shoes. I'm talking about like those old school golf shoes with the big metal spikes. I don't know why. I don't know why you did it. But I hope you feel better, like you got one over and you were able to, you were going to, I don't know what your magic words were you were going to say, but apparently you thought you had magic words. You thought you were going to wow and, you were going to give him the pizzazz. You're going to hit him with the Riz. What did you hit him with? This judge thinks you're a fucking asshole. You go into court, act like a complete dickhead twice, where the judge has to time it out and put a timeout because you're acting like such a fucking fat. Yeah, that's the Chad move. That's the pro gamer move. Pissing the court off and acting like a harassing fucking psychopath. It's like that meme goes. Like that's big brain thinking. But honestly, though, Patrick Melton, you should find new attorneys because Nick has poisoned the water hole, and Frank White and Brian Lewis are fucking idiots, and they've done nothing to make the situation better. So you really should get your own attorney. Get someone else. These guys are not going to help you. Nick is not someone you should be relying on for legal advice at this point. Like, you're better off just going on your own and figuring it out because can't do much worse than the Knicks. Like, I assume you're smart enough not to go into court and start talking about Aaron's penis and talking about him eating goo and, calling people faggots in court. I think Melton's smart enough not to do that. And already he's going to be light years ahead of Nick. Get a better attorney. You need new attorneys, man. These guys are not helping you, and they will not help you. I mean, you still got your own problems of not showing up to court and all that, but that's a separate matter for a different day. You need to get somebody else to help you. Maybe that attorney can negotiate something where you could get this all reset without showing up. I don't know. But Frank White and Brian Lewis are not the droids you're looking for. They are not going to help you with this. Save yourself. Save yourself, because you really want to go down with this ship. You really want to go down tied to Nick as he's flailing around and drowning. That's not the way to go, man. That is not the way to go. And I'm being honest. Not like, if you want to keep that rope between you and Nick tied on, I guess, but get a better lawyer. Even Kayla isn't using Frank White and Brian Lewis. She's trying to find a different lawyer for things for her HRO. She's finding her own lawyers. Even she knows they suck. Get different lawyers. Get different lawyers. There you go, chat. There you go. That's the update you've all been waiting for. So